Hello, 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 everybody, and welcome to Military Parents in New Jersey 101 Rights and Responsibilities, our webinar for today. We're going to talk about how state and federal laws and branch policies affect child support, visitation, and support for military families. If you remember, we did a webinar not too long ago regarding military divorce. This one's going to focus solely on military parents and their rights here in New Jersey. Of course, our disclaimer, this presentation contains general information, does not constitute legal advice. Be sure to direct your specific questions about your own case to an attorney. Weinberger Law Group is not affiliated with the United States military. The sections we're going to cover today: military parents in New Jersey, rights and responsibilities again, our introduction and common procedural issues that we face, child custody and parenting time, child support, and military benefits for children. So let's first talk about common procedural issues facing military parents and a little bit of a brief introduction for military parents here in the Garden State. So the laws and procedures for military parents here in New Jersey involve issues that revolve around child custody and visitation or child support, and they can be especially complicated for military families due to the interaction of New Jersey family law with military regulations and policies. Now, state courts make their own orders based on state law rather than enforcing the military branch policies. Frequent moves of families sometimes result in confusion regarding which state or sometimes even which country is the appropriate authority or which state has jurisdiction for issuing and enforcing court orders. And certain laws provide special protections to military parents. So choosing the right court and the right procedure. Now, depending on your circumstances, the appropriate state court may be in your state, it may be the other parent's state, or it may be the state with jurisdiction over your child. Jurisdiction gives the court authority to make decisions. Claims for custody, visitation, child support may be part of a divorce case, or they could be started as a separate, what we call non-dissolution procedure. In New Jersey, claims are filed in the Superior Court, Chancery Division, Family Part. Now, jurisdiction. Jurisdiction in child custody matters is determined by the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, and you can see the legislation there that covers it. Jurisdiction in child support matters and in parentage matters is determined by the Uniform Interstate Family Support Act, or what we call UIFSA in New Jersey, and you can see the legislation there for that. Now, jurisdiction for child custody and visitation under the UCCJEA. Let's talk about that a little bit more. Now, a state can claim jurisdiction of a child for those kinds of matters under any of the following circumstances. The state is or was, within the last 6 months, the child's home state where the child resided. If it is in the best interest of the child for the state to have jurisdiction due to a significant connection with the state. If the child is physically present in the state and has been either abandoned or is in need of emergency protection, or no other state has jurisdiction and it is in the best interest of the child for the state to exercise jurisdiction. Also, the original court generally retains authority unless the child and both parents have moved out of the state, or if there is a mutual agreement to transfer jurisdiction. So if New Jersey was where the child originally stayed and the child leaves, usually New Jersey would retain jurisdiction. Even if a child is a U.S. citizen, jurisdiction may belong to a foreign country. Now, New Jersey law states that if a child is living out of state on a temporary modification order, New Jersey will keep jurisdiction, will remain the child's home state. Now, jurisdiction for parentage and support orders. We talked about this earlier. This is governed by UIFSA. The UIFSA addresses a court's authority over the parent paying support, also known as the obligor, sometimes the payor. Now, the court must have personal jurisdiction over the obligor, either because one, they reside in the state, or they have engaged in purposeful action as further specified in the act, which creates a reasonable expectation that the state court would gain authority. Also, the obligor can voluntarily submit to the jurisdiction of the state. They could just say, listen, we volunteer to have New Jersey have jurisdiction, even though it may not in any other circumstance or situation. Now, orders from other states or from foreign tribunals, other countries. Only one tribunal has exclusive and continuing jurisdiction under the UCCJEA and UWIFSA. Other state courts recognize and enforce orders from the state that has jurisdiction, but they won't change those orders. So if you have an order for custody from North Carolina, New Jersey will enforce it, but they won't change it. When jurisdiction belongs to a foreign country, enforcement may depend on any agreements between states and countries that exist out there. Without an agreement, a state court can still decide that the law and procedures of the foreign country favor enforcement. If you have an international jurisdictional dispute, absolutely consult an attorney because this can get really quite complex and complicated. Let's talk about some state court procedures, specifically providing notice to your child's other parent. You must give the other parent a chance to respond to whatever it is you're filing by serving copies of your papers according to the applicable rules. Now, this could require service by mail, regular certified return receipt, personal service off post. Sheriff's office or a process server can do this off base or off post, or personal service on post. You have to contact the commanding officer of that post or the provost marshal and follow their instructions on how to serve a military person on post, because usually civilians are not allowed to just roam free on bases. Now, what about parents overseas? Service overseas can be really especially difficult. If you know that you or your child's other parent may soon be deployed overseas, try to handle any urgent situation before they leave. Now, Hague Convention countries generally permit service by mail to a quote-unquote central authority in the host country. In non-Hague countries, these are countries that are not party to the Hague Convention treaties that were signed. The procedure will depend on the agreement between the host country and the U.S. military there. Now, there's also the Service Members Civil Relief Act. This is important. This is a federal law that extends various protections to service members who are on active duty, including protection from default in civil suits. Now, the purpose is to allow military personnel to devote full attention to the defense of the nation and not worry about not responding in time to papers. Now, the time frames for responses, answers, cross motions, etc. may be extended upon request of the service member. So, again, consult an attorney who's knowledgeable in the SCRA for more information. Now, a stay of proceedings is possible under the SCRA. A judge cannot enter default against a service member unless the service member waives their protections or if the court first appoints an attorney for the service member. Now, if the attorney cannot contact the service member or the court finds that current military service or service within the past 90 days is somehow affecting their ability to appear and present a defense, the court will stay or hold off on hearing the proceedings for at least 90 days. Additional stays or stays after notice require an application, including the following: a statement from the service member indicating how their duties are affecting their ability to appear, and a date that they will be available to appear in court, and a statement from their commanding officer indicating that military duty is now preventing the appearance and that leave is not authorized. Courts will routinely grant requests for telephonic appearances from service members if they're unable to get to New Jersey due to the fact that they're stationed out of state. Now, opposing a stay of the proceedings. The service member is required to act in good faith and exercise due diligence in trying to arrange to appear in court. If the service member is exaggerating the difficulty involved in making an appearance, or if their personal appearance really isn't necessary, the other parent may oppose the stay of their proceedings. Let's talk about child custody and parenting time here in New Jersey and military policies involved with that. Now, New Jersey family law with regard to child custody and parenting time is governed by state law. You see the statute there, and it is NJSA 9:2-4 if you want to read a little bit more about that. But the overriding concern is always the best interest of the children. New Jersey absolutely favors frequent and continuing contact with both parents, and parents are really encouraged to make their own agreements. Parents can agree on any combination of physical custody, legal custody that addresses a child's best interests. Military family care plans. The U.S. military does not allow single parents to enlist. In most cases, this includes parents who have joint physical custody. Parents who separate during service may end up as single military parents, and this triggers certain responsibilities. All single parents in the military, as well as military parents married to another military parent, must have a family care plan, FCP, in place. Now, FCPs cannot conflict with court orders, and a non-custodial parent can request a change in a court order that conflicts with an FCP designating another care provider. The court will consider these family care plans, but will not enforce it if it violates the rights of a parent or if the court finds that the plan is not in the best interest of the child. Remember, that's the overarching concern of all the courts. Now, when forming your family care plan, make sure your commanding officer is aware of the provisions of any existing court orders. It is highly recommended that a service member provide their CO with a copy of any and all court orders discussing custody and care of their children. This can include a judgment of divorce, property settlement agreements, custody arrangements, etc. And the same can be really annexed to the family care plan, so it becomes one and the same. Service members must notify commander, supervisor, or designated representative no later than 30 days, 60 for the National Guard or Reserves, following an occurrence that creates a single parent or military couple with children status. Within 60 days, again, 90 for Guard or Reserves, the service member must submit their family care plan. Active service members who move from one military base to another have 60 days to find a short-term care provider within the new local area. Now, each branch has its own requirements for the family care plans, but all have three basic components. 1, designation of a short-term care provider. 2, designation of a long-term care provider, and details regarding care provision. So the short-term care provider, a non-military person or military spouse who signs the family care plan can be considered a short-term care provider. The provider must agree in writing to take over immediate full-time care of the service member's children at any time in the event that the service member is called to active duty or deployed without notice. The provider must live in the same local area as the service member. Now, the long-term care provider is a non-military person who signs the family care plan. The provider must agree in writing to provide long-term care for the service member's children if they are deployed for a significant period and or is selected for an unaccompanied overseas tour or is assigned to a ship at sea. The long-term care provider does not have to live in the local area, different from the short-term there. Now, the plan must specify how care will be transferred from that short-term provider to the long-term provider, including specifying travel arrangements and financing for the transfer. If the kid has to fly from Florida up here to New Jersey, how is that going to happen and who's going to pay for it? Additional care provisions that are in the plan. Either the consent of any non-custodial parent not named as a caregiver or an explanation for the lack of consent. Financial arrangements for short-term and long-term separations. Provisions for financial, medical, and legal support to ensure security and continuity of care, such as powers of attorney or allotments. Logistical arrangements and transportation expenses for any relocation that might happen of the caregiver or family members. And provisions for any necessary non-military escorts for infants, children, elderly, or disabled adults during their relocation. New Jersey family law addresses parenting during service-related absences. Now, deployment can be unpredictable and require difficult adjustments. Active duty can certainly increase the risk of physical or psychological injuries. A New Jersey law enacted in 2013 addresses the need for special flexibility in child custody arrangements and parenting plans when one or both parents are in the service, and that law can be found at the citation you see there. So protection for service members in New Jersey custody and parenting time matters. The timing of orders. New Jersey law prohibits permanent custody decisions to be made while a parent is absent for 30 days or more due to either deployment or perhaps treatment for a service-related health condition. Courts must wait at least 90 days after the parent's return before entering any permanent child custody orders or making permanent changes to any already existing custody and parenting time orders. Parents' responsibilities. The departing parent has to notify the other parent of the anticipated absence dates and locations no later than the day before departure or the 10th day following receipt of official notice, whichever is earlier. Now, to the extent possible, the non-departing parent must facilitate electronic, like email or telephone communication between the child and the parent who is absent. Changes to any custody or parenting time orders or awards are temporary. Temporary modifications must allow the departing parent to exercise parenting time during leave and must expire automatically when the parent returns home. Original orders resume after the parent returns home unless the other parent can demonstrate that this is not in the child's best interest. Enhanced flexibility. A parent cannot base a request for a change in custody or parenting time on the other parent's absence due to military service or treatment for service-related health conditions. Children do not automatically stay with the non-departing parent. The court will consider other options. For example, the child may stay with the other parent, but the child also may accompany a deploying parent. The absent parent may delegate parenting to another family member with a close personal relationship to the child if the child is not going to stay with the other parent for whatever reason. Now, factors courts consider in determining appropriate modifications. Temporary modifications will be based, as always, on the best interests of the child after considering all relevant circumstances, including which parent has been the primary caretaker of the child? What conditions would the child face in the deploying country if the child is going to move? What's the safety situation? Are there child care facilities? What about enrichment opportunities? And what kind of arrangement will with the other parent or an alternate caregiver provide for the child? Is it in the best interest for the child to go with the other parent or with an alternate caregiver? Now, what about the hearings? Expedited dates and presentation of evidence is a little bit different for military parents. A parent facing an imminent deployment or treatment-related absence that would prevent appearance or full participation in a custody or parenting hearing or an evaluation even can request an expedited date before deployment without waiving any rights to stay the proceedings under the SCRA that we talked about earlier. If a parent is already out of the state, courts can take evidence and testimony by electronic means such as telephone or even an internet conference. So what about child support payments? How do military policies and New Jersey law work together with respect to payments? Well, in New Jersey, typically payment of child support is governed by state statute. You see it there, NJSA 2A:34-23, and there's also court rules that impose additional specific guidelines. If you don't have a court order or an agreement addressing payment of support, branch regulations or guidelines govern temporary support payments. Now, to note, not all branches of the military have specific guidelines providing for support. A service member's failure to support dependents is considered to be serious by all branches of the military, and they can result in disciplinary action for the service member. So what are voluntary support allotments? If you are an active service member and wish to voluntarily acknowledge paternity and provide support for your child, your commander will assist you in obtaining the appropriate available housing and dependent allowance, understanding what you need to do to complete a voluntary allotment for the child, obtaining military identification for your child, and obtaining ordinary leave consistent with military requirements in order to marry your child's mother. So the Navy policy, support is payable at different percentages of gross pay, depending on whether there is a spouse only, 1/3, a child only, 1/6, or a spouse and one child, 1/2, and etc. For details, you could see the Navy Personnel Manual 1754-030. The Marine Corps policy has minimum support payments based on the number of dependents or, if higher, a percentage of the housing allowance. To see more specifics regarding this policy, see Chapter 15 of the Marine Corps Legal Administration Manual. The Army regulations, minimum support payments vary depending on living arrangements and military or non-military status of your spouse. Now for details, see Army Regulation 608-99. The Coast Guard minimum support is calculated as a percentage of base pay according to number of dependents, also factoring in differences in housing allowances with or without dependents. Now, for further information on that, see the Coast Guard Discipline and Conduct Manual, and you see the section there, 2E3, support requirements in the absence of a court order. And the Air Force policy. The Air Force directive defers to state courts for calculations on how much child support needs to be paid, but the minimum support must be adequate. And if you want more details about that policy, see the Air Force Instruction 36-2906. Now, in New Jersey, under New Jersey family law, how do you obtain enforceable support orders? Voluntary support allocations under branch regulations are not enforceable in court without a child support order. If the father was not married to the biological mother at the child's birth and paternity is an issue, this will need to be addressed first. Both parents can certainly sign an acknowledgement of paternity. Putting the father's name on a birth certificate in and of itself is not sufficient. If the mother does not want to sign, then the father may need to have genetic testing done. The state child support agency can help with DNA testing. So we have to establish paternity. Establishing paternity ensures that a child will have certain legal rights, including inheritance rights, health coverage, and other benefits such as pensions and possible veterans benefits. Establishing paternity is the basis for custodial or visitation parenting time rights, as well as for financial support. It can also be important for the health of the child because it can reveal genetic risks for certain medical conditions down the road. So what is military income available for support? Military income available for New Jersey child support and or spousal support includes both basic and special pay, as well as any benefits provided in lieu of pay, such as food and housing. The service members LES will include amounts for basic pay and any special amounts they're getting, such as for jump, dive, or flight pay. Now, calculating available gross income for support requires review of the military service members' statement and assessment of an appropriate value for any benefits received that's not traditional pay. Now, what about deployment or call to active duty? Service members with child support orders who are called to active duty must notify local child support offices with information regarding date of activation, new address, and military branch. For support recipients, this guarantees ongoing support without interruption. For support obligors or payors, this provides protection against changes that may be made in the obligor's absence due to inability to locate them. The service member can complete and file an authorization and release form from the state agency designating another person to receive information about their child support case during their absence. Now, what about modifying child support due to activation or deployment? Activation or deployment may substantially change income, creating eligibility for a change in child support. The parent requesting a change needs to file a motion for modification in court. If you have a wage withholding order or a wage garnishment order, contact the probation division or the administrative office of the courts in the family division to avoid the risk of having your wages garnished or your wage withholding stopped or recorded as delinquent. So how do you enforce payments? A court can sometimes proceed with an order for temporary support, even if a service member is attempting to stay the proceedings. A hearing may be held via telephone conference. Parents with an order for payment of support from the New Jersey Family Court or from the New Jersey Office of Child Support Services can request wage garnishment through the Department of Finance and Accounting Services. Some additional enforcement remedies: federal income tax refund offset. The IRS can take or intercept federal income tax refund and send the money to the Federal Office of Child Support Enforcement, which then sends it to the recipient parent. Liens on real or personal property. If there's a lien on someone's home for failure to pay child support, this would prevent them from selling, transferring, or borrowing against the property until the child support debt is paid. Same goes with bank accounts. This may apply to accounts at banks or other financial institutions. Suspension of licenses may apply to driver's licenses, professional licenses, occupational licenses, and even sporting or recreational licenses. Passport denial. A civilian passport may be denied if the obligor is more than $2,500 in arrears. And additional remedies. Other remedies are available through the court process, including potential incarceration for failure to pay. Enforcement by wage garnishment. Now, branch regulations of the military require service members to honor support orders. Each military branch has its own wage garnishment procedures. Now, for those who don't know, wage garnishment is actually having your child support automatically removed from your paycheck. There is a federal statutory allotment procedure specifically designed for military obligors. The service member receives actual advance notice of the implementation, and within the first 30 days after notice will be offered an in-person consultation with a judge or legal assistance, a legal assistance officer to address the arrearage. The federal procedure can only be utilized if there is a court or administrative order establishing child support, so you have to have a court order, an arrearage of at least 2 months support under the obligation. Only when those two things happen can you have the service member's wages garnished. What about enforcement of child support between states? Now, under UWIFSA, a state's support order can be filed in a second state where the obligor parent has income or assets. The parent receives notice of the registration of the order, and he has an opportunity to contest that registration, the underlying order, or the statement of arrears. If the registered order is confirmed, the court or agency of the second state will enforce it according to their laws. Now, what about health care for children and military benefits that provide those? Well, there's the Defense Enrollment Eligibility Reporting System, or DEERS. DEERS is a computerized system that keeps track of all recipients entitled to military benefits. All of a service member's dependent children, whether they live with the service member or not, are eligible to register with DEERS, provided that a military installation with an ID card issuance site has determined that the child relies on the service member for more than 50% of their support. So to enroll children in DEERS, required documents include a certified copy of the child's birth certificate and, if paternity is an issue, a copy of the paternity order or signed acknowledgement form. A non-military custodial parent can also enroll a child into DEERS by mail by contacting a military installation or unit with a Rapids ID card issuing facility in the same service branch as the military parent. The parent will need the documentation showing eligibility and the military parent's social security number in order to do this. Now, what about obtaining medical benefits through TRICARE? Once registered with DEERS, a child will be able to receive treatment in a military facility or a civilian hospital under TRICARE. Children under 10 can use the parent's ID card, but all children should have their own card if they don't live with the service member. Here's some great references and resources. You can find a U.S. Department of Health and Human Services Administration for Children and Families Office of Child Support Enforcement guide called Handbook for Military Families at the link you see there. Now, more information on New Jersey family court procedures with regard to support, custody, and parenting time is available online from our state judiciary, and you can see the link there. More information on military health insurance can be found at the TRICARE site, www.tricare.mil. And information about military policy on single parents can be found in the American Bar publication, Silent Partner Custody and Single Parent Enlistment. And you can see their website right there. For more information on New Jersey child support or child custody for service members or their spouses, please visit our website, weinbergerlawgroup.com, or consult one of our books on military divorce, child custody, child support, and more. These are available on Amazon.com. If you have other questions about military divorce in New Jersey or really any other area of family law, give us a call. You see our toll-free number there, 888-888-0919. You can shoot us an email at info@weinbergerlawgroup.com, or we actually have an Ask a Question section of our website where you can ask your question and you'll be replied to by one of our attorneys. Of course, if you need to, you're always welcome and able to schedule your free, confidential legal consultation to discuss your divorce, your child custody issue, your military child support issue, whatever you may have. Call us, schedule your consultation, talk to one of our attorneys. Again, if you wish, you can visit our website at www.wlg.com. We have lots of resources there, including blogs and other webinars that you can take a look at. Or again, if you want to ask us a question via email, there's our email address, info@weinbergerlawgroup.com. We hope you enjoyed this webinar. We hope you got some valuable information. And of course, as always, we hope to welcome you back next time and hope you join us again. Again, if you have any questions, give us a call, shoot us an email, and we look forward to hearing from you. Thank you. Again, if you have any questions,